Okay, great. So thank you so much for joining me. We are going to be talking about title to your home and how important it is to make sure that you know how title is held and some of the ramifications and problems that can occur as a result of title maybe not being held the way that you want. So my name is Krista Hermans. I'm an estate planning attorney. Our firm is Hermans Law, where we do estate planning with the focus on families with minor children. So that is not only who we help, though. I found that when I started the practice about 6 years ago, that families with young kids didn't know that they could do planning to make sure that their wishes were legally documented. And so that's really where we focus on educating, but we do help all ages of clients. And so I think my oldest client right now is 95 years old. So we, again, help all ages. In addition to that, we also do, when somebody passes away, the probate side and trust administration to help families to kind of get through that once somebody has passed away. So our attorneys, we have amazing attorneys that work at our firm in helping families put plans in place. Our office is a very family-oriented firm. And so it's making sure that, we have that flexibility for any of our team members to make sure that while they do enjoy working, they also want to make sure that they are there and present for their families. And so that's really a really big thing that we really strive for at our office. Okay. We have offices in Ventura, Westlake Village, Santa Clarita, Calabasas, Pasadena, Irvine, and virtually throughout the state of California. Before COVID hit, we were doing virtual, working with virtual clients, but since COVID's hit, it's really just expanded us being able to work with clients throughout the state of California. California is where I'm licensed. As well as all the attorneys at our office. So we can help anybody in the state of California. If you are not in the state of California and you need assistance, please reach out because we do have attorneys all over the country that we work with. Okay, so let's get to it. So when you are buying a home, it's really important to understand how title is held. And I feel like, as someone who's gone through this process, as well as the refinance process, there's not a lot of information that's given when you are getting to this part, right? It may be something that's just kind of casually asked. I've seen it in the refinance side where somebody who has a trust, they go through a refinance and it's never explained to them, at least in the clients that I've dealt with, what's going on with how title is being held. And I feel like that's why this is so important. It's really important to make sure that you understand. And when I talk about buying a home or anything when it comes to having title in your name, it doesn't matter if you have a mortgage on the house or you don't, right? If the house is paid off, it is still, from what I am referring to, it is still the same thing when it comes to title. Okay. Okay. So there are different ways to hold title when you are purchasing a property or refinancing a property. I've seen that a lot recently with all of the refinances that are happening. People that have held property one way, they do a refinance and then they're holding it another way. So different ways to hold title. So whether you're single or you're married, you can own title in your own name. And so if you are married and you own title in your own name, you might see in your title that it says as your sole and separate property. Okay. Even if you're married, it could say that, depending on, again, with that refinance I've seen, maybe the refinance is done where only one spouse is on title. And so it's then that one spouse that owns it as their sole and separate property for the refinance aspect, right? And oftentimes I see that when clients come into my office and we're doing their plan, I'll ask them, did you know that this is only held in this one spouse's name? And if it's meant to be community, is that they own it jointly, they don't know that it's only in one spouse's name, or they don't understand that. And so that's why this is really so important to make sure that you're going through this. Another way to hold title that I find is probably what I see is the most common is joint tenants with right of survivorship. And what that means is that if you own a property with somebody as joint tenants, you have equal share of that ownership, right? It's an equal share. And if one of you were to pass away, everything would then go to the other person that's listed as the joint tenant. So it's with right of survivorship, meaning it just passes directly to that other person by operation of law, right? There's documentation and stuff that has to be completed when somebody passes away, but it doesn't go to their heirs, the person that passed away. It goes directly to that other person. I see this a lot if maybe siblings were to inherit a property. I see this a lot with spouses when they own a property, and I'll ask them, was it your intention to own it this way? And a lot of times they just didn't even know. Another way is what's called tenants in common. And it's similar to joint tenants, but what tenants in common, you can actually own it as different percentages. And so, I will see this one if you have somebody that maybe owns, one person owns a third, and then another person owns 2/3, right? So they have unequal distributions in the property. But what it also means is that that percentage or that share, however much they have, rather than it going with right of survivorship where it passes to the other person listed, it actually goes to the person's heirs or their beneficiaries if they have any type of estate planning documents like a will. And then it says who their stuff goes to. It doesn't go to the other person, right? Like with a joint tenancy, with that right of survivorship, it doesn't automatically by operation of law go to the other people listed. It goes to their heirs and beneficiaries. I see this come up more often than not where people make title changes and I don't know why, right? People will just quit claim property to different family members. There's all these kind of changes that happen. And what can often happen is that if you own property as joint tenants and you quit claim something or you transfer the deed, it can what's called sever that joint tenancy. And then it would be owned as tenants in common. And this happens where now it doesn't just go to the other person. That share then goes to the heirs. But in order to get to the heirs, it would likely have to go through probate court. And I'm going to talk about probate court because I feel like this is a really big portion of having title, because this is where I see issues come up for families, is then that portion, let's say that 1/3 and 2/3 distribution is tenants in common. That 1/3 distribution person passes away, they have no estate planning documentation. Well, that 1/3 share, in order to get to their heirs, that 1/3 has to go through probate court, right? That 1/3, that percentage of that property has to go through probate court, okay? Another way to hold title is husband and wife is community property. Husband and wife is community property with right of survivorship. So those are different ways to hold it. And what that means is that you have husband and wife that are legally married, recognized by the state of California, and that they own it as part of the community. California is a community property state. And so there are certain tax advantages to owning it as husband and wife as community property. With the right of survivorship means that it's going to the other spouse. By not having that right of survivorship language in there, there could be issues for the family. If one passes away, it may not automatically go to the surviving spouse, right? So there's certain aspects of it from that you should understand depending on how title is held. So some of the potential issues that I see, and if you have any questions, please put them in the chat or the Q&A, and I will try and save a little time at the end to get to some of these questions. I can't give any legal advice, but from an informational perspective, I can try and just give you the information. If you do have any questions that you feel are specific, it's always best to make an appointment and work with an attorney to understand, what the ramifications are, or what kind of plans can you put in place to fix those? So some of the potential issues that I think are really important, and I find that these come up a lot when it comes to title. So adding children to a deed. This I see is common for maybe where you have adult children and maybe one spouse has passed away, and the remaining parent wants to put their child on title so that if something were to happen to them, it doesn't have to go through probate to be able to get to that child. So issues that I've seen that can come up with that is, well, what if you have more than one child, right? Now you're just giving your house to that one child. And then thinking that, oh, my child will take care of the rest of the kids. That doesn't happen all the time, right? I've seen it where literally kids get disinherited by not having some type of estate plan, because it just goes to one child, and that child then they have title, right? It's now in their name. The other thing that I don't think people understand when they do this is that there could be ramifications when it comes from a tax perspective. There could be reassessment. There could be, parent-child exclusion issues where maybe they don't get the same step up in basis value. There's all of these different kind of things when you just add your kid onto title when you're healthy. Another really big one that people don't take into consideration is that once you add somebody on a title, like you're adding your child on a title, that if that child has any issues, right? If they're getting sued, if they have creditor problems, those creditors can attach to your house. They can put a lien on your house. So your house could have to go through foreclosure, right? If they have these issues or these lawsuits where creditors are attaching now to your house because they're on title, right? It's like they own the house. And so that is one really big thing that I don't think parents take into consideration when they just add their kids to the deed. Okay. Another really big one is if you have blended families. And so in a blended family situation, you have, let's just say you have a husband and a wife that get married and they have adult children from previous marriages, right? They each do. And so now you have these two kind of families that are coming together. Well, what if you have one side of the family, let's just say the wife, where she has the family home that, the adult children have had their whole life and she lives there, and, she has this new spouse and they get married, but then she puts the new spouse on title where they own it as, and I've seen this happen a lot, they will own it as joint tenants with right of survivorship. So what does that mean? That if mom passes away, if it's joint tenants with right of survivorship, it's not going to her kids. It's going to her new spouse. And maybe that was her intention, but maybe it wasn't. And maybe she didn't understand what was going on when she changed this title, right? Because now if that's the case and she added new husband as joint tenants with right of survivorship, if she passes away, her kids don't get the house. It all goes to the new husband. And if there's no estate planning documents in place, he can do whatever he wants with the house, right? He passes away, it goes to his kids, right? It's not even that, it's not even that he's not taking her kids into consideration. His kids are his heirs. It's not her kids. And so it's not that he's going to do something bad. It's that is the way that without any estate planning documents in place, California intestate law says that his kids are getting his stuff, right? So I'm just trying to kind of give you some ideas. These are things that I see happen when there is this type of blended family situation where, somebody gets remarried and then without having any type of estate planning documents in place that make it very clear what the parents would want, kids could get unintentionally disinherited from their parent because there isn't legal documents that say what should be done. Okay. Another potential issue is with joint tenants. And so with joint tenants, when I explained it before, you have, let's say, two people that own it as joint tenants with right of survivorship, right? With that operation of law, just if one person passes away, it automatically passes to that other person listed. And so when people don't understand that is the way that it works, that where I see this is if siblings inherit a property, they own it as joint tenants with right of survivorship, their portion then doesn't go to their family. Whoever is the surviving person then controls and they get the estate. And so if it's siblings, joint tenants with right of survivorship, one sibling passes away, that sibling share that passed away doesn't go to that sibling's kids. It doesn't go to their heirs. It goes to the other sibling. And now that sibling has 100% of the property and they get to distribute it to their kids, right? And so that other sibling's kids or family gets left out. right? And that's why it's so important to understand how title is held and what ramifications can happen, what consequences can happen by title, because they all mean something and it's very different. And that's why it's important to know what could happen, because once you know, you can make the decision that says, well, yeah, I'm okay with that. And that's fine. But if you're not okay with it, then you can put the legal documents in place to make sure that it's changed so that if something did happen, it would be distributed according to your wishes, the way that you would want it to be. Okay. Another issue that I've recently seen, especially with so much in the refinancing realm, is when you refinance and you have joint owners. So specifically, because like with joint tenants, right? Anytime you're doing a refinance, you have to have all of the people that own the property in agreement to do the refinance. And so in a situation that I've seen where a mom had put one of her kids on title, and the kid and mom had an issue, and mom wanted to either sell the property or refinance it. I've seen it a couple different ways. The kid, who is now is fighting with mom, refuses to sign off, right? What's mom going to do? Take her kid to court? She has to, because they refuse to do anything. And they have the ability, because they're a joint owner, they're now on title. Doesn't matter that they owned it, that mom owned it first. Kid is now on title. The adult child is now on title. They're refusing to act. Another one is if you own it jointly with somebody and then they are incapacitated. And when I say incapacitated, is that there is something that happens from a health perspective where they don't have the mental ability to make financial decisions on their own. Maybe they had a stroke. Maybe they had a car accident. Maybe they had just this medical condition that they've just gotten worse. And at the point that they are no longer able to have the ability to understand what's going on, they don't have the ability to sign documents. And so now if this house has to get refinanced or even sold, it may have to go through court to be able to get a conservatorship for this person so that somebody can sign off on their behalf. Okay. Okay. Again, if you have any questions, please put those in the questions and answers, and I will try to get to those at the end. I do want to be mindful of your time, and I do want to try and finish on time. Okay, so let's go through how to solve some of these issues. But to do that, you need to understand what happens when someone doesn't have legal plans in place. So like I was just talking about with incapacity, if somebody doesn't have the mental ability to make decisions on their behalf, then there is this court proceeding called a conservatorship. That is where the court is going to say, this is who has the ability to make decisions for you. When there is this conservatorship, it is very expensive. It takes a long time to do. It completely puts all of the affairs of the people involved out in the public eyes, right? They're all court records. And you have a judge making a determination of who's making that, who's going to be in that position to manage it on your behalf. It may not be who you would want. The other thing is that when somebody passes away, there is what's called probate court. I've kind of mentioned that before. Probate court is that when somebody passes away, any assets that they own in their own individual name, and this is required for estates over $166,250. That is the number in California that estates would have to go through that probate process. If they own and like in California, if you own a home in your own name, and to be able to get to your heirs, it has to go through probate. And a lot of times people don't really understand that. They don't think about it from that aspect. So why do you want to avoid probate? Well, probate is a very long process. It can take 1 to 2 years, and that's uncontested. That means nobody is saying, no, that's not the way things should be distributed. It's just everybody's getting along, and it's just the time it takes from a statutory period to go through the process, as well as the courts have a lot of cases. And so it takes a long time to get on calendar. The other thing, like I mentioned, is it's public. Anybody can go down to the court, pull the documents, find out what you owned, who you owe money to, and who your beneficiaries are, right? They can pull all of that information. The other thing is probate court is very, very expensive. Probate court in California, just to give you an idea, if you have a gross estate with a fair market value, where your home has a fair market value of $490,000, right? Not how much you owe, not how much your equity is. It's just the fair market value. You have about $10,000 in various bank accounts. Probate estate of $500,000. Well, probate fees in California are set by statute. So the statutory fees for the attorneys and the personal representative are $26,000. That's for a $500,000 estate to go through probate. Okay, you add on costs. So filing fees, probate referee fees, publication fees, bond fees, all of this stuff, you're looking at $28,000 to almost $30,000 for a $500,000 estate. The more that estate value goes up, $800,000 house, $1 million house, those probate fees are going to go up. Okay. On my website, we have a probate fee calculator. If you want to know, or you want to share with somebody that you're trying to make sure that they get this stuff done, have them do the probate fee calculator to just get an idea of how expensive it would be. Okay, so what type of legal planning documents help avoid some of these issues that I talked about, right? To help avoid any of those things with the blended family or the joint tenancy with right of survivorship. So you have a will. A will is a legal document in which you give certain instructions to be carried out after somebody passes away. In your will, you say how you want your stuff distributed, right? If you have money or property, this is who you want to distribute to. A will also allows you to nominate guardians for your minor children. In your will, depending on how it's set up, your kids can get money when they turn 18 years old. When somebody passes away, a will is filed with the probate court, right? Therefore, it is then made a public document. If somebody passes away in the state of California and they do not have a will, their estate is distributed to California's law, right? It's California's will for you. It's their way of distributing it. And again, that is called intestate law. I kind of mentioned that a little bit earlier. One of the biggest myths that I hear from people when it comes to wills is that they will say, having a will avoids probate court. That is not true. A will alone will not avoid probate court. If anything, it guarantees probate court because it's telling the court, here's how to distribute my stuff. Okay, so a will alone is not going to avoid probate court. If anybody tells you, oh, I have a will, we don't need to worry about that, it doesn't avoid this problem, right? All of that cost, the time, and everything that goes through it. So how do you avoid probate court? Well, we have what's called a trust. And specifically, it's called a revocable living trust. Some people know of it as a living trust. So what is it? Well, it's basically just an agreement between the grantor, which is the creator of the trust, where they put specific instructions in writing to the trustee, which is the person who agrees to hold legal title to all of the assets in your trust. And they do this for the benefit of your beneficiaries. So I just threw three big terms at you, right? Your grantor, your trustee, and your beneficiary. While you are alive and you have a revocable living trust, you are all three of these roles. You are the grantor, meaning you're creating it. You are the trustee, meaning you are in charge over all of the assets in your trust. And you're also the beneficiary. It's all there for your benefit, right? You're not losing any control over any of the assets in your trust. When you have a trust, generally there's no court involvement, which means, staying private, keeping the costs down. And the biggest myths that I hear about trusts are that trusts are just for wealthy people, right? I'm not Bill Gates level. I don't need a trust. Well, that's not true, right? If there's anything that you just got from the stuff that I was talking about probate court, if you own a home, right, having a trust is enough to avoid probate court, right? Having your trust or having your house in your trust is enough to save all of that money, to keep things out of court. And that's what you would use it for, okay? So what are some of the benefits of having a trust? Well, if you have a trust and you own your home, even if you have a mortgage or you don't, then you can put your you can put your home in the name of your trust, which would then avoid probate court, right? So we look at the title and we say, well, how do you own title, right? Let's say you own it as husband and wife as joint tenants with right of survivorship. So then now you own it as trustees of your trust, right? And that is what is on title for your home. And that avoids your house having to go through probate. When you have a trust, you can also set up subtrusts. So if you have children that are younger, you could say, well, or grandkids, you could say, well, I would want my kids to receive money at 25, 30, and 35, rather than going through that probate system and receiving money when they turn 18. Having a trust allows you to protect your children's inheritance from predators, creditors, and divorce, remarriages in the family. You can also choose a trustee to manage your finances for your children if you need one. Also, if any of your kids have a lifestyle disability, right? If they have a drug problem, an alcohol problem, They they get sued a lot, right? There's creditor issues. There's all these different ways that you can put plans in place to protect it. Another benefit is being able to list your trust as a beneficiary on accounts so that the funds don't go to minor children if you have them. So like life insurance, if you have $1 million life insurance policy and something happens to you and your spouse and your kids are minors, you wouldn't want them receiving the money. So you could put the trust as the backup beneficiary so that that money goes to the kids at 25, 30, and 35, rather than through the court system when they turn 18. Okay. So who needs planning documents? So anyone over the age of 18 years old should have some type of estate planning documents, whether, if it's college kids, having advanced healthcare directives, power of attorney documents, things that make sure that their parents can be involved. But especially if you own a home, you should have some type of planning documents to make sure that your wishes are legally documented the way that you would want things to happen if something happened to you. Okay, so question, do you know how title to your home is held right now? If you do not, we will send you your deed for free. You need to send an email to info@hermanslaw.com, put in the subject line, free deed, please, and include your name and address of the property in the email so that we can send you that deed. I want you to know this stuff, and it's very confusing. This email is just going to be an opportunity for you to know. And then if you want to schedule a consultation to go through what does that mean if something happened, then that's what we're going to do, right? We're going to help you try and figure that out. If you need help getting your estate plan completed, making sure that you have a trust so that your house is in your trust, please schedule a 30-minute free phone consult. This is going to be an opportunity for you to just understand what our process is, to be able to understand, what are the things that we can do for you? How much does it cost? And how do we get started? Okay. Okay, I'm going to go through questions. I'm also going to put in the chat the link to be able to schedule. Actually, I can't do it at the moment, but I will send it in an email to you. So being able to get your free deed as well as being able to schedule a free consultation. Okay, I am at 30 right now. So 12:30, I'm going to wrap it up there, but I am going to save some time for some questions and be able to get to those for you. But I do want to say thank you so much for joining me. If you have any other questions, please put those in the questions and answers or in the chat, and I will get to those. Okay, so just getting to the questions now. So when you refinance and place someone on title and you are doing it as joint tenants, automatic that they get right of survivorships? Do we need to specify this when adding people to title? So if I understand the question correctly, when I see this, when you refinance and you refinance it with somebody else, joint tenants with right of survivorship, that is automatic. It's just by operation of law. That's what joint tenants means. I always like to have the language in there because then it makes it very clear. But joint tenants, if it doesn't say with right of survivorship, that's what joint tenants means, is with right of survivorship. How do you find out how title is held? Is there a person I should ask or a document I should reference? So email us info@hermanslaw.com with that subject line, free deed, please. And we need your name and the property address so that we can provide that to you so you can see, okay? I'm single with no children. My deed is named in the name of my trust, so my condo is funded through my trust. Is it paid for? It is paid for, no mortgage. Am I in a good position? Do I see any other issues? So the first thing I would do is just I would have an attorney review title to make sure, is it held the way that you want it to? Because this is where I see it happen with refinancing, especially, is you think it's held in the name of your trust, but then a refinance happens and it gets moved out of your trust for refinance purposes. So that would be the first step. You are more than welcome to email us and we can work with you to see if you're a client, and I recognize the name. And so I don't know if this is a client of ours. I at least recognize the first name, just to make sure that you're good in that sense. Okay. Can you provide services for people outside of California? We cannot. So we are only licensed in California. Throughout the state, anybody in the state of California. If you live in California, but you have properties in other states, we can still assist, right? We work with other attorneys in the other states to get the property moved into your trust in California. So we can help with that. But if they physically live in another state, we can't help, but send us a message and we can send you a referral to an attorney in your state. Does a will and a living trust supersede putting someone on title? So generally, the title is what is going to be what is going to kind of overrule anything else, right? Because the title is the asset, and the will and the trust, if something isn't in the trust, then title doesn't matter, right? I mean, the property doesn't matter because title is saying it's the same thing with beneficiary designations. If you have a life insurance policy with a beneficiary designation, that is what it's going to look to, and it's going to do that first. It doesn't matter what your will says, who you want your stuff distributed to. If the life insurance doesn't go into it, there's nothing to distribute it. So title for the property is what is going to kind of win out over the will or the trust. That's why it's so important to make sure that all of this from a planning perspective lines up the way that you want it to. Okay, that is all I see from questions perspective. I will give it one more minute. And again, I'm going to go to the chat real quick and see if I see any other questions there. But thank you so much for joining me. I do these webinars on a monthly basis. So if you have anybody that you think would benefit, please make sure to forward these to them. Make sure to get on our email list so that you are in the know when we have these. And I'm going to get to just a couple more questions here. Okay, how do you remove someone from title if they inherited a percentage of the home? So that is a very specific question. Generally, we actually will work with a real estate attorney to understand what the whole impact would be, right? And they may advise, because we want to look at it from a tax perspective. If you change title, is there going to be reassessment? And so usually we'll work with a real estate attorney to come in to assist in looking at the chain of title to figure that out. So my husband and I added his daughter to deed in case something happened to both of us. Was this a good decision? So in the beginning, I talked about not adding your children. There's so many things that could happen as a result of adding a child, right? So if that child was added to the deed and they get sued, then they can put a lien on your house, right? And so that's one of the big things that I've seen in having that. There could be issues. There's other ways to do planning rather than adding your child onto it. Okay, I'm going to finish with this last question. Can you explain married community property versus joint tenants? So community property, there's different ways to hold it. So I actually have seen this very frequently just in the last few weeks where people owned it as community property, but they didn't own it with right of survivorship. And so what that means is that if it's owned as community property with nothing else, and one spouse passes away, part of the portion goes to the surviving spouse, the other part of the portion goes to the heirs. If it says with right of survivorship, then it all goes to the surviving spouse. And so there's different ways from that aspect. Owning it as community property, there is you can get a step up, what we call a double step up in basis from a tax perspective, that if one spouse passes away, there is a step up in basis from the time that you purchased the property until the time that spouse passed away. But if you own it as community property, you would get a double step up in basis, or your estate would. And so then when your children would inherit it, that double step up in basis, only owned as community property, that means that they wouldn't have to pay any capital gains taxes from the time the property was purchased, from the time that spouse, the surviving spouse, passed away. So there's a huge tax benefit to owning it as community property with right of survivorship. I usually say that too. And so we want to make sure, if that's the intention, right? I'm not saying go out and change title to it. It's understanding how owning it, that there are some advantages to it. When you own it as joint tenants, that you don't get that double step up in basis, right? Because you're not owning it as community property. And with owning it as joint tenants, it is by operation of law that if one person passes away, it automatically goes to the other person. With owning it as community property, if you don't have that with right of survivorship language in there, it may not automatically go to that other person. Okay, so something to think about from that side. Okay, thank you so much for joining me today. I really appreciate it. And you will get an email with some of the links that I talked about. So if you need help, if you have questions about title, trying to figure out the best way to make sure that whatever you want is legally documented the way that you want, I recommend doing a 30-minute free consultation to get some information to get started, and then working with one of our attorneys to be able to put that plan in place, right? Generally, trusts are what we're going to recommend, right? Because so that there isn't this issue, because then things are avoided from a probate perspective, right? That's what we're trying to do, is we're trying to make things easier for your family. Okay, thank you again for joining me today, and have a wonderful day.